And we're off. Make law better, the legal innovation agenda in vectors and phases. So my opening statement is the most trivial and obvious of all observations. Notwithstanding the submarket or the country in question, law is failing to deliver value commensurate with the costs that it imposes. There are many reasons for the challenges that this industry faces, but I think it's the most simple explanation I could offer is that this has historically been a field focused around selling subject matter expertise, typically by the hour, and not a field focused on operational excellence. So notwithstanding this critique, it's not all doom and gloom. There are an increasing number of folks working globally to advance what might be called the legal innovation agenda. So when we talk about innovation in law, this is what the media's favorite story is, the robot lawyers thesis. And seems like a day or a week doesn't go by where we don't have another one of these stories about, you know, the rise of the so-called robot lawyer. Now, I've never met a robot lawyer. I'm sure there's one out there somewhere. Maybe if you meet one sometime, let me know about it. It's like seeing Bigfoot or something like that. But the stories keep coming out about the robot lawyers. I think, the company that sells the clip art here is making quite a bit of money. They particularly like the Terminator 1000 there. That was previously played by Arnold Schwarzenegger, if you know the movies. But in the end, this has been a kind of thing that's been coming at us, a range of outlets all across the world about robo lawyers, automation, what have you. This is probably peak robot lawyer, but you never know the peak till you're after the peak, because tomorrow I could wake up and there'd be 5 more stories in the FT and the New York Times and other outlets around the world. So one of the things I wanted to talk about tonight is there's much more to this innovation conversation. I think it's reflected in some of the curriculum that you're putting together here at Bucerius and with other parallel law schools around the world are kind of going down this path. And legal tech is an important and material component, but there's more to the legal innovation agenda than just legal technology. I think probably one of the distinguishing features here is, though, this is not the law of technology. This is technology or innovation for the law to make law better fundamentally as a field. Most of what you see innovation in law is people are talking about how there's innovation in society and law has to regulate that. And that's a perfectly valid inquiry, but that's not what I'm going to be talking about here tonight. So you can break down legal innovation into 5 vectors at least. There's probably more, but these are at least some of the big items. So here's 5 components we might break it down into. Market structure and dynamics, productization and scale, process improvement, AI and legal analytics, and intelligent monetization. So starting with market or market structure, there's obviously no legal market per se, but a bunch of sub-markets, and they operate with slightly different dynamics. My friend Bill Henderson sort of breaks it out like this. There's a core legal profession, there's a legal services industry, and there's a broader legal industry. So legal tech, for example, goes in that outer band. And some of the items in legal tech are getting fused with the core profession or with the services industry. So like law companies, for example, would go in this legal services band. Big Four would go in this legal services band. Not the core profession, but doing things that are right in the zone of the work that lawyers historically have done exclusively. If you broke out the markets, you might say, who is the client and what is the offering? Who is the client and what is the offering? So large companies, say Fortune 1000 or Russell 5000, large global companies, mid-cap or mid-sized companies, retail, and then access to justice. Those are types of clients. And then the offering. Historically, law has been a service business, so people sell services typically by the hour. Now we've seen products sort of emerge in the space, and I think the quest for a lot of these organizations is how to build product-service bundles. Because usually the products in the market don't solve the complete problem, but neither does the service in an economically sort of rational manner. So the question is how to fuse those two things together, as I see it. So you could spend a bunch of time, and certainly over a longer curricular kind of opportunity than we have, say, tonight, you could go into a detailed treatment of each of these submarkets. But when we talk about disruption, I don't think it's any one of these things itself, but it's the sum of things coming together all at once, disruptive trends. Obviously, law firms compete against other law firms. That's that hardly needs to be stated. But there are these other players in the ecosystem, entities sometimes that are getting increasing treatment, but historically weren't seen as kind of the core players. And this is at least some of them. Big Four, law companies, legal tech, and the clients themselves. So just in terms of scale, if you look at Deloitte or PwC, they're larger than the sum of the 10 largest law firms on the globe. So they have more developers. Deloitte, for example, has more developers than the largest law firm has total people, including everybody in the building, every single person. So just in terms of scale, they operate. So they look at the legal market as an attractive opportunity in a variety of different jurisdictions, because there's a lot of things that are adjacent to law, like an M&A transaction has financial elements which bleed into law. And actually, law is the less important aspect of the transaction than the economics, which is generally driven by the accounting firms. So they're edging in on this or fully in the markets, depending on the regulatory structure of the given jurisdiction, including even in the United States, which has been a pretty hostile jurisdiction when it comes to the accounting firms practicing law. A lot of writing about this. They flirted with it. They've come close to it in a bunch of different jurisdictions. Some they're fully in. But EY, I think, is particularly interesting in this context. So they started by buying a smaller player, Riverview Law, who was one of these first wave kind of law companies. But I think a much more material thing was going to Thomson Reuters and buying Pangea 3, which was one of the bigger outsourcing businesses that there was out on the market. And so that's a much more material bet on the kind of, we are going to move into the law. We're going to move into the law space. Thomson Reuters sort of went the opposite direction, which is said, we're not going to build the product service bundle, basically. We're going to double down on the tech and get back to their core business. This was a sort of a journey they went on with Pangea. So law companies I mentioned. I'm affiliated with this one, but in fairness, there's quite a few players playing in this space. Elevate's one of the fastest growing private companies out there, but United Lex is a very big player also. Locations all over the world. Axiom, of course, is a large player also. They'll be going public. They just filed their S1, so they'll be going public probably in 2019, towards the end of the year, I believe. This is their kind of journey. They all started off as labor arbitrage businesses, so that's the idea that, hey, we have a very expensive lawyer in a ritzy location who's being paid a lot of money. Some of what they do could be sort of given to somebody somewhere else, like in India or like in the Philippines, or even in somewhere else in a country where the cost basis is cheaper than, say, a place with very expensive real estate or something like that. What happens is that sort of runs out. That sort of runs out as a business. You can only take that so far. Then you say, well, we're going to take cheaper labor and combine it with better processes. And that sort of runs out. And then you get into this, well, we'll integrate data and technology into it. And so that's what that field has been running through this sort of gauntlet. But I actually think it's the whole industry has run this track, actually. Is first you sort of try to play with the deck chairs on labor arbitrage, and then that runs out. And especially if the clients are paying more and more attention to the economics of what you're doing, then you sort of say, well, let's do project management and process improvement. And then that sort of only goes so far. And then you get into this data and technology integration sort of exercise. So I think they're the phrase is canary in the coal mine, but they're a kind of leading indicator of what I think you'll see for other players in this space. So legal tech, over the past few years, we've seen significant growth in the sheer number of startup companies. Some of them aren't really startups anymore. They're like, medium-sized businesses. There are a variety of different lists out there. Here's one called Angel List. There are just about 1,000 companies listed under legal tech here. These are venture-seeking or venture-backed startups. AngelList goes across every sector. So it's not just, it's like there's healthcare and there's fintech and there's legal tech and all the different economic sectors that there are out there. Stanford has a list, about 1,100 companies there. There are companies that are in none of the lists. There are companies that are only in one of the two lists. There's at least, we're probably pushing 2,000 globally. Legal technology startups was a US-UK thing, and kind of the rest of the world came online. So this is just a bunch of countries, and people build these product maps, and they say, what are the different, and the colors here kind of indicate people who are doing a similar sort of exercise. And, some of these companies will succeed and some will fail, but that's what startup is. It's high risk, high return sort of exercise. But just to kind of look here, Austria, Switzerland, Belgium, the Netherlands, Spain, Australia, Israel, Brazil, Mexico, Asia, Africa. I didn't even put Germany in here. I figured that's pandering to the group here, so I won't do that. But the point is, there are product maps in all these jurisdictions, and the point is the, it was just it's the world has now come online for legal tech, because basically my view is the legal business is fundamentally the same business everywhere. It's run under the same. You could parachute into another part of the globe, and it's going to be sell services by the hour. The business model is fundamentally similar. The laws are different, but basically the business is highly similar. So the same problems are being resolved in other jurisdictions with slightly different laws, slightly different contexts, but they're like, we need to build machines that can analyze contracts. And we want to predict outcomes in litigation, except in France, because you go to jail for that. That's a joke. You can read about that offline. Anyway, so the customers themselves. So every customer in a sector figure you can either do it yourself or you can buy. And the clients have, in increasing numbers, said, no, we'll just do this ourselves. It's particularly things that are routinized. Why am I going to pay a law firm to do this when we have a repeated problem of this nature? I'll hire a full-time person and I'll have them just do this. It's a pretty rational thing. So this is in the U.S., but a similar sort of pattern is you'll see in other markets. In-house is, if you've ever touched that area, the economics are so concretely clear that it makes more sense in a lot of contexts to hire FTEs, full-time employees, than to outsource the work to a law firm. And so that's where most of the growth has been in the kind of what might be called the core industry, 200% growth. And in support of that, we've seen legal operations rise, and that's why there's a summer program in legal operations, not just legal technology, but legal operations and technology, because legal operations is an increasing function that corporations are trying to use to procure legal services in a kind of economically reasonable manner, including doing it themselves. So if you clock the first one, 2016, I spoke at it. There were 450 people. They were at the St. Francis in San Francisco. They basically that was the max capacity of the conference facility. So the next year, they go to the Bellagio in Las Vegas, 1,200 people. This is 2017. 2018, 2,200, and I think they hit 2,400 or something like this just this year. They just had it. There's yours truly talking about AI. So legal operations is this growing function. A bunch of companies have gone down this path of trying to rationalize the purchase of legal services and products by putting an operations professional in charge of it. By the way, this is no radical concept in a company. Lots of companies have head of operations in all their units of the business. So the law was historically an anomaly. It was unusual that a unit of a business would not have an operations professional. The COO is the head of all those operations lieutenants across a given corporation. That's a very common idea. So legal operations is a very logical idea if you sort of think about the org structure of a typical corporation, because operations professionals typically you'll see them in every segment of a business as a historic matter. So productization is scale. Again, law has been a service business where people sell subject matter expertise by the hour. I think it's becoming something else slowly. People are beginning to productize their legal knowledge. It's another way to deliver it, the knowledge you people have, and it's taking us into this corner of pure products. And I think the thing everybody's really working on, how do we blend our services with the products? Because a lot of the solutions to the problems are neither products nor services alone. It's the combination. Hard to put them together. That's a challenge. I won't go into this, but basically, everybody is trying to get into somebody else's square. That's the takeaway. Everybody is trying to figure out how to carve up somebody else's market. And it's good. It's competition. So it's good for the customer, for the consumer. And we're trying to bring the cost of law down so that it can be more sort of economically rational. One of the things that products helped you with is the just-in-time imperative. You can't scale labor instantaneously. You can't just get 1,000 people tomorrow when you have some huge exercise. It's easier to scale technology than to scale labor. Products are nice because they also help you cross-sell services. That's the bundle idea. And they can be blended with services, as I said. And this is something the Big Four are great at. Products make you very hard to get rid of. You can switch law firms. It's much harder to get rid of an accounting firm when they have 17 software programs in your organization. Unwinding them is very difficult. And just from a pure kind of Silicon Valley math right here, a product business has a much higher multiple on it. So most law firms, what would you get? 1.6 times revenue. That's what you'd get on a service business. By the way, you want to test that assumption. We just had an upper mid-sized law firm go public in the United Kingdom. They got 1.6 times revenue. And I think that's frankly pretty generous. What do you have? High-priced labor, no IP, no products. That's about right. That's about right. And what would you get a product business? 3x revenue, 5x revenue, 7x revenue. If it's really good, 10x revenue or something like that. 1.6 for a labor-centric business with high, expensive labor. That's about right. So tech is a capital-intensive field. And law firms have historically had trouble accessing capital because before you could go public, there wasn't a way to get capital. By the way, I think that go public idea that firm had is they only sold a fractional piece of the law firm. So now they have access to capital. So the goal is, if it were me, deploy that capital to build products and then sell them another chunk of the business at a much higher multiple. That's what one would do. Like if you hired me as your management consultant, that would be my suggestion to you. You need capital and you need a way to take these ideas and turn them into products. Where you're going to get the capital, go to the capital markets and go public. That's the only way that I could think of for you. So one thing you say, various firms have created these engagement frameworks designed to build product service bundles in one form or another. This is the response to all those technology companies, all these startups happening. I was involved with the first one at Denton's, a little less involved now, but this was a good idea, so all these other firms copied this idea. And they did their own version of do we do an incubator or a startup or startup incubator, we build our own products or various sort of versions of this idea. And this is just a subset of them. So if your firm's not up here, please just understand I could hit the down arrow for the next 4 minutes without running out of examples. But just to as illustrative examples, all these firms have done some of these are more serious than others. Of course, having a press release and a website doesn't make it real, but I think some are more serious than others. Now, to me personally, I'll pick on them, but I consider this to be one of the more conservative British law firms. And if they have an incubator, then we're all legal technologists now, unless the Queen has an incubator. If she has an incubator, then that's another level above this. In other words, the fact that they felt it necessary to go in this direction. If I had told you 5 years ago that like all of the Magic Circle firms will have an incubator or some version of that, people would have said that will never happen. Never happened, and it has completely happened. So process improvement. Across the entire economy, there are efforts to take something that might be called an artisanal process and turn it into an industrial process. By the way, the reverse of that is being a hipster, right? Taking something that's industrialized and making the perfect latte art. That's the opposite of this phenomenon. But there's this effort to industrialize work that is done from an artisanal basis. The intellectual origins of this go back a long way, certainly to here at least, or to here. It's not just, by the way, about efficiency. It's about operational excellence, which means fewer errors. That's what this was all about. Lean and Six Sigma was about operational excellence, fewer defects, fewer errors. It's not, people sort of think it's all about efficiency. It's actually about doing the work better. So the key when we go to white-collar work, these ideas come out of manufacturing physical objects, not white-collar work. The pin manufacturing example from Wealth of Nations or building cars or something like this, there's not a one-to-one translation to white-collar work. But the idea is that we want to maintain the artisanal elements that add value, but to try to put some process or rigor around the rest of it. So this is my friends at Sci-Farth have this picture. They're one of the better-known law firms, probably the best-known law firm in the U.S. for bringing process improvement methods in their work. They said, well, here's 3 processes. Same process, 3 versions of it. Here's the process as we think it is. Here's the process as it actually is. Here's the process as it should be, where should be is measured by the person. Is the person paying for this knew what you were doing? Would they pay you money for it? Is it actually adding value, or is it just, gee, we've always done the work this way? When anybody says that, that's just how we do things around here, it means they have no independent justification for the exercise that they're undertaking. They're just, well, the person before me did it that way, so I'll do it that way today. So I think these methodologies, there are others, but these are the two best-known process improvement methodologies. Lean and Six Sigma can help every subsector in law, every single one of them. And the goal is to take a high volatility process and turn it into a lower volatility process. Now, typically, you don't control all the variables, so it's not going to go to this, but you take something that looks like this, and you turn it into something that looks like that. Not this. That's very unlikely. And what you're left with is a useful artifact when you do these process mapping exercises. These are in people's minds. These are in people's heads. A senior lawyer knows these processes. The problem is they can't distribute it to a team because you can't peer into somebody's head. You can run a more effective team if you can distribute your processes and information across other folks, especially as you scale in complexity and team members. The ability to run a coordinated exercise when it's all in people's minds, it's pretty well documented across a lot of different problem spaces. It tends to fall apart. Things it can help you do, having better processes, increase response times, increase margins, predict your resource loads, and coordinate across large groups of stakeholders. I'm very happy to get to co-teach this class at my school. We teach a process improvement, project management process improvement class, 15 weeks with the folks from Sci-Farth, which is a top 100 U.S. law firm. Okay, AI and legal analytics. This is a topic on which I'm asked to comment upon quite a lot, and I could give a full-fledged presentation. We'll keep that for another day. You can access more here, AI and Law 6-part primer. But I'll just kind of hit the highlights here. AI is a very big field. A lot of it isn't super germane to the work that lawyers do. Like computer vision is great for building driverless cars. Not so clear how it helps you, but you can come up with a corner case where it might. These are the big ones. ML, or machine learning, natural language processing, and expert systems. And this is the big divide in AI between methods that are data-centric and methods that are rule-centric. So expert systems is the kind of canonical rule-based approach, and machine learning and NLP is the classic now data-driven approach. You can combine them in certain examples, but I just want to give you, if this is your first pass on this, I want to give you a taste for the kind of division that exists out there. So I'll start with expert systems. Richard Susskind's probably the most famous legal futurist in the world. And he has permanent technical credibility because he built the first expert system in law in 1986. And it was about processing one statute. And it took him a calendar year to build this system. And it was, is my claim time barred by this statute? So that knowledge engineering task is very, very labor intensive to just build a system that could answer a discrete question. Now, it was a question that took a lot of time for somebody to answer, but this was always the canonical problem with an expert system is how do I do that knowledge engineering when it comes to, is it worth it economically, let alone is it feasible? And I think the biggest issue wasn't the feasibility, it's the economics that really stood in the way of expert systems deployment. Some contemporary examples, and just to give you the idea. The idea is if you can represent a problem as a set of if-then statements, if this, then this, if this, then this, if this, then this, then you can represent it in this kind of methodology and turn it into software. The most commercially successful version of this is tax preparation software. In the US, this is a system that has 30 million users. Taking a very complex tax code and representing it as a bunch of if-then statements where people answer questions and their tax form is getting filled in. People have taken those set of principles, this is the company best known for this, and deploying that across other problems in law where people are trying to represent, these would be the set of questions you'd ask a person to try to understand what their legal problem was and what the proposed solution or outcome might be. My school, Chicago Kent, together with Cali, has built an expert system authoring software. It's actually up over 4 million people have used this software, but it's for legal aid organizations to help them produce software that can help folks navigate various court processes or legal processes. So they have to fill out a form. Well, the form is very hard for them to fill out. They don't understand. Many of the lawyers in the room would think of these as being some of the easiest problems in law, but to the public, those are still very difficult problems. This is something that's meant to try to make it better for them to go through a judicial process. But it's just if this, then this, if this, then this. So the first move is that these things become chatbots. And that really is rules and data. This is Expert Systems 2.0, except with a better front end. Better two-way engagement. But it's just, a person wrote me a natural language statement in their own words. Can I figure out what the real problem is? And can I interrogate that by asking the right follow-up question, given the way they've represented their problem? The other half of this equation is data-driven AI. So instead of having hard coding the rules, let data do the lifting. And if this distinction isn't clear to you, let's think about maybe the canonical AI exercise of our time, a driverless car. You can two approaches to learn the rules of driving. We still want to know the rules. The question is, how do you learn them? One is, I have somebody write down the rules of driving from first principles. If you tried to do that, you'd be sitting at the desk for your rest of your natural life and many lives. Alternative is, watch a bunch of people drive a car and learn the rules of driving. Predict the outcomes that they would undertake. Person steps out in the car, in the road, slam on the brakes. Car swerves in, move to the side. You think about that, there's a bunch of rules that people follow. You follow rules when you drive a car, or the person driving the bus or car or what have you, and you do it instinctively. You don't think about, oh, if this, then this, and so forth, but that's what's going on. ML, NLP, and natural language processing critical for our field because this is a very language-centric field. Other fields, it's not. Driverless cars, language isn't so critical, and just in very kind of narrow ways. Mostly, it's not that. And here, language is the coin of the realm, as they say in law. So NLP is just the statistical representation of language. And so language is so critical to our field. We spend countless hours in law schools like this teaching people the language of law in very, very precise detail. So the question is, how much of that precision do we need to teach a machine in order to have them effectively complete a task? So one thing people want to do is predict a set of legal outcomes. Here are just a few use cases from law. Predict relevant documents. That's e-discovery or e-disclosure and due diligence. Predict contract terms and map those to outcomes. Predict rogue behavior. Predict case outcomes and costs. And this is sometimes called RegTech, but kind of lawyers who work as lobbyists are trying to develop strategies to achieve a certain set of regulatory outcomes for their clients. Whether clients are public interest folks or they're companies or whatever, they're trying to achieve a certain set of outcomes with regulators. Yeah. So there are an increasing number of relevant academic papers and sometimes companies associated with them who are trying to do some class of prediction of the outcomes of a case. Remember, we're already in the prediction business in law. In other words, somebody comes to you, you process up here using this apparatus, and you try to tell them. They don't just say, well, we have no idea what will happen, and good luck to you. No, you try to offer some probably very hedged statement like, it depends, but I think we should do this versus that. I mean, there's all this gymnastics people do, but at the end of the day, they are picking a strategy for their clients or trying to suggest one to their clients. And so this is a notion that if you have no predictive ability, then you ought to identify that and tell them, flip a coin and make a decision. And people don't typically do that and charge all that much by the hour, so they try to have a little bit better handle on things. So these are just a few examples. Predicting securities fraud class actions. This is predicting the European Court of Human Rights. This is a pure NLP paper. Patent law. This is more transactionally oriented, but there's all types of transactionally oriented strategies. Do we put this language versus this language in an agreement? All those types of things. The question is, could data teach us how to do that better? This is our paper on predicting U.S. Supreme Court decisions. There's been many others all around the world doing some version of this with their high court, statistically predicting what would happen in the cases, and then seeing how well could you do. It's not 100%, but most of the time we've tested it with human experts, not 100% either. And this is really an important point that needs to be made. Blending streams of intelligence is typically better than any single stream of intelligence. And this is probably a statement about the whole economy. Humans plus machines are better than humans or machines for almost any task. The only question is whether the economics of doing the combination are justified in the example. But this is borderline axiomatic. But again, it's not always worth it just because you can do it. So when they wrote up our paper in Science, this is what I said. Experts, crowds, and algorithms, actually, these are the three things in human history we've ever used to predict some outcome. Experts, crowds, and algorithms. The canonical example of a crowd is a market. So I was recently at an event where there was a significant focus. There's been all these AI products that have been built. I would say that a lot of them are very narrow point solutions, and a lot of the customers are looking for more flexible tools. People say, oh, I have a proprietary black box software that cannot be adapted. That doesn't work when, humans can make these jumps very easily. Machines are not good at making these jumps. That's general artificial intelligence that doesn't exist. So the problem we've had is, first we just got all these companies, but to get started, they tend to pick this very narrow problem to work on. And it's logical because you have to get some customers or your company's going to go under. It's very rational to start there. The problem is you take that same toolkit and project it on another problem and it doesn't work. It doesn't work because it wasn't engineered for that. So this was a big focus of this conversation last year at Clock that I was a part of. It was called Brutally Honest AI, like dispatches from real-world projects. This is what I want you to think when you think AI. It's this three things put together. And some AI toolkit, a subject matter expert, and some data scientist who can do the engineering into all the other problems. Something like this. The expert is going to audit the output, try to understand the basis of the mistakes, feed that back into the system to try to make it better over time. Here's just some of the use cases. These are some of the operation side of things. I won't go into all these. Litigation, these are all the things I said some of this earlier, but just to give you a little bit more gloss on the topic. And transactional. And then you can divide the transactional world into two, everything that happens up to the execution of an agreement and everything that's done after, typically in batch. GDPR, LIBOR, Brexit, RevRec, due diligence, all of that is done with executed agreements, typically large numbers of them. Okay, and then there's all the stuff that happens in negotiation, all the optimization of that particular exercise up to the signing of an agreement. So that's the division of the transactional world. So as people begin to craft solutions to these problems, it's going to take people in this direction. Off of the kind of AI fantasy and into data science, I think open source is going to win here. I've made a bet personally on that, and machine learning as a service. And I said more on that here. But why? I just want to say a couple words about why open source. We have all these systems in law that are totally fragmented. A finance system, a matter management system, a contract management system, if there even is one, all these different IT systems that really don't work together very well. They're not operable with one another. A lot of the toolkit, a lot of products that have been built are not extensible to all the other problems, and we don't have a common data model. This is a classic problem other fields have faced. Medical informatics has gone through this and has made a lot more progress because they've already had to fight through this problem. Doesn't mean everything's perfect over there, but they've had to slog through this. Like an electronic medical record is an effort to try to create a common data model so that we define a certain type of patient outcome in a similar way so we can provide insights to medical researchers, for example. My organization, my team is practicing what we preach. We've open sourced our code base. You see on GitHub. We have kind of three things. We have LexNLP, which is a general natural language processing library. We have Contract Suite, which is a contract-specific open source offering. And the only part that's proprietary is the UI. That's it. On GitHub for your dining pleasure. We've been working with a number of firms. We'll have another announcement here in the next week or so. Another large. We have other firms that. Some people think if they have a proprietary thing, they don't want to talk about it. In other words, we work with other firms. These are just ones that we've been public with. But LexNLP, here's a paper about it for your consideration. What we need is natural language processing for not general language, but specific legal language. This is, again, very parallel to medicine. Medicine's gone through this thing. Most NLP was built on these general corpuses of English or German or Spanish or French. General. Like they take all of the news articles and aggregate them as a way to teach machines language. But what do we do in here? Teach people very specific technical language. And they do this in medicine and in engineering and all these other fields. So to think you're going to take a system trained on general language and project it into a highly specialized lexicon, not likely to work particularly well. That's what this is about. So intelligent monetization. One of the challenges that legal innovators have faced is problem selection. And in law, I think pedigree beats performance every single day. Why? Because we don't measure anything. It's not a statistical field. People don't say, who does better? They say, oh, that person, they're smart. They went to a good school, or, I'm friends with them. But it's not rigorously measured. That's our field, because we're not quantitative. Every time there's been a benchmarking study in this field, globally, the experts have not come out nearly as well as we think. And the truth is that even if you have a better mousetrap, even if you're 5 or 10% better at something, you need a customer or client who actually cares. Oh yeah, those of you who are general counsels or what have you, you're part of this problem too. It's been easier sometimes to sell legal innovation ideas to people who are impacted by legal decisions or legal risk, rather than the underlying players in the market. But this is actually kind of a general phenomenon. In the whole economy, the boundaries between markets are beginning to evaporate. Like, I don't know at the margins what the difference between these 6 things are. Legal tech, gov tech, deal tech, reg tech, fintech, insurance tech. I'll tell you this, there are conferences on each one of these topics as if the other thing doesn't exist. But I think more generally, aspects of what lawyers do, and this is the link to my previous talk here, but there won't be much of it, is actually finance and insurance in the first place. Always was. Today we use lawyers as the computers of legal risk, but in the rest of the economy we use things like underwriting and risk transfer vehicles to manage risk optimally. So here's some examples of law as insurance. Reps and warranties insurance is the representation of legal risks as insurance. Title insurance is law as insurance. Litigation funding is legal risk being managed like another asset under management. Notice, by the way, Warren Buffett is one of the largest litigation funders. He tends to find the right side of these bets typically. I would say to lawyers, I know every case is different and nothing can be predicted, but somehow these guys made all that money. That's one of the biggest litigation funders out there. Because you can predict this stuff, spoiler alert, at the portfolio level. In the individual case, whatever, portfolio, 1,500% returns. Then there's event-based legal trading. We've done work on this. In other words, decisions by lawyers, by judges and regulators affect publicly traded companies. If you could predict those, the best place to manage that, to deal with that, is just go to the securities market and trade. I have no secret information. Just take the public record, predict it. So I was happy to see this written up in the FT big read earlier this year. Legal signal processing. So I don't think robot lawyers is nearly as much of a threat as financialization to the work that lawyers are doing, because I consider it to be risk that is not managed in the optimal manner given the rest of the way other risks are managed in the world. There's a lot more where that came from. Where law is finance, it's going to look more like finance. I like this here. Law firms are going to work on monetizing bespoke AI models. That will make it look like high-frequency trading or proprietary trading does. And that's this idea which I've talked about here previously. So with that current understanding of the inputs, dynamics, and constraints, I want to close with a handful of kind of ideas that are a little further over the rainbow. Everything I talked about is a version of the present. Not everybody, I've learned there's alternative facts, there's alternative presents also. So I think we're on this path from chaos and complexity to actual reinvention of a field. So I've been teaching this blockchain class at my school, blockchain law class. And one of the things I sort of orient people is, we've actually been on this much longer arc from hunter-gatherer societies to a highly complex global economic order. And if you look at economic history, you can see it as this quest to kind of scale trust and lower transaction costs. And, just kind of showing you these are big steps along the way, obviously omitting huge things along the way, but these are some key ideas. If you were to divide up recent history and project forward, I think you could take the last 150 years and say, there's an analog era, there's a digital era, and we're actually already in the computational era. And the key idea is that each layer kind of each era layers upon the era before it. And sometimes the combination of something in one era with something new creates a whole other set of possibilities. But you needed the two ideas together. Independently, you didn't get there. The World Economic Forum calls the period we're moving into the fourth industrial revolution. And what they mean is a lot of fields have gone from computerization and automation, or what sometimes we call digitization, and it's actually in this world of cyber-physical systems. Law has not really made the digitization transfer completely yet. That's actually a challenge for us. I personally would call it the computational age. One is because I have this blog called Computational Legal Studies, so I'm pot committed, as they would say. I'm required to call it computational age. The key ingredients of this era are these three things: AI, crypto infrastructure, and the Internet of Things. And it's not one of these independently. It's actually the combination of those that unlock a lot of possibilities. And I think these map on to what we're seeing in legal innovation, past, present, and future. Analog, digital, computational. Analog is chaos and complexity. Digital is some process and predictability. Computational is really, that era is about reinvention and real value creation. So I'll give you a few examples on the path to reinvention. Let me start with contracts and transactions. This is what it looks like: chaos and complexity. Chaos and complexity. Word is the contract management or contract negotiation platform via email. Not you, but somebody next to you, probably. So the first thing you try to do is come in and put some process and predictability around what you're doing and say, hey, we're negotiating all these contracts. Let's try to just keep track of stuff more effectively. And by the way, this is completely necessary. So there's nothing wrong with doing this. But nobody's going to give you an award, or should give you an award, for doing something that the rest of the economy has done a long time ago, which is, hey, what's our volumes of stuff? What's our loads on stuff? Can we measure? Can we have some measurement of what we're doing every day? That's just kind of traditional kind of business management kind of brought to law. That's not real reinvention. These contracts, I know we're very fond of, and I am in kind of longer arc smart contracts. Computable contracts are much more immediately valuable and necessary. Contracts are full of computations, including multiply this number by an interest rate at a future time state, all of that stuff. That's the simplest computation you could have. They're full of compute this when this happens, so forth and so on. But we represent them in natural language, which means some human has to always do the translation, or we have to force it through a machine with all the kind of failings of natural language processing machines, instead of just representing them as computations to begin with. I know some jurisdictions are better about representing these things more computationally than others, but this is a very clear arc. What they really want to be able to do is push and pull data. Push and pull data. That's what contracts really want to be able to do. Let me give you an example of cyber-physical legal infrastructure. This is a crop insurance contract. If you don't like the crop example, cross that out and just say any insurance contract where there's a contingency in the world that changes the validity of a claim from not valid to valid. What are the facts in the world? Don't think about writing a contract the way you do today and think you're just going to map it directly into this. This is actually an opportunity to ask, how can we make a contract into an executable? I think we'll have these Frankenstein contracts, by the way. It'll be part natural language and part code living side by side. Because there's some times where you just need the natural language. Like if I went to a judge and I'd say, well, please audit my code here. What do you think, Your Honor? Probably not going to work, right? So we're going to have to kind of live in this dualism for a long time. So here's how this works. You have sensor data that's processed and served up and stored on a trusted ledger, might be called an oracle. Doesn't have to be a public blockchain. It can be a private one that's used on a subscription as part of the contract. You have a bot that's constantly looking for, in this case, whether a drought has occurred, because a drought is a condition that pays somebody a certain payout on the crop insurance. And the crop insurance contract is, you normally would get this amount and you only got this yield till you get the some factor of the difference. There's a lot of fraud in crop insurance because people move the grain. So the better thing to do is just peg it to weather. But then you need an oracle, some trusted source of what the weather was. There are examples of this in all over finance that are cropping up, not in legal tech, really in fintech. But to me, that's really legal tech by other means. If contracts were structured data objects, then things like this would not be nearly so difficult. This is the Great Lawyer Make Work Act of 2019. Let's go through all these contracts because LIBOR is going away. This is a big payout. I think Ernst & Young said that they're projecting $350 million a bank. times 16 global banks. Why? It all starts from natural language not being a great way to represent this. If you could have this represented as code, then you would either know the contingency or know that you would immediately be able to audit where the hole in this contract is vis-a-vis LIBOR and be able to remediate it, including renegotiate it. Sometimes there's a fallback provision in this. But again, just to give you a very concrete and immediate example of this problem that's going on right now. Again, a lot of law firms are going to do very well because of this, but this is an opportunity to ask fundamental questions about why we allow these types of remediation exercises to happen over and over again. Second thing is the discovery, compliance, convergence. So the very things that people are looking for after something bad has occurred are the things they ought to be looking for after the fact. Like rogue trader blows a hole in the bank, heard that story before. Somebody bribes a foreign official. Some report from an engineer didn't make it to the right person and then more people died than should have. This stuff happens over and over and over again. Even this happened again. The goal should be prevention. Now, can you prevent every form of bad behavior out there? Of course not. But some of these are the same story over and over and over again. So how do we solve that problem? Have you ever had your credit card turned off before because there was anomalous charges? Because there's a behavioral pattern and you have some algorithm that trips the system and hits pause? Again, some of this behavior is so anomalous you could never come up with it. Some of it's the same thing over and over and over again. So in the military, they call it signals intelligence. My friend Ron Freeman calls it do less law. Do less law. In other words, solve the problem fundamentally rather than clean it up after the fact. I think we're going to see the rise, we're seeing the rise of new legal platforms. We've had 2,000 point solutions bloom in legal tech, and even though most of themselves call themselves products and platforms, the vast majority of these are just point solutions that solving relatively narrow problems. This is where this goes, just like in the rest of the economy. Because the cost of sale is very high for each of these individual solutions. Also, if you're the purchaser of those at the law firm or corporate legal side, you have all these vendors coming at you and you can't rationalize all these things and you don't even know what to pick among all of these things. We're going to have, the 2020s will be the platform story for law, for legal tech in particular, and APIs. And you're seeing some of the bigger players in platform-style players in legal tech try to suck up all the startups and put them available in a kind of app store offering that's sold to law firms or to corporate legal departments. They actually kind of go in a different direction, which is there's two stories of platform world. One is you try to build all the applications yourself, or one is you just run the app store and you let the people battle it out. My bet is on the people that try to do the App Store version of this. This is probably the most notable of one is Rending Court. Sign up all these big law firms using containerization technology. What they're doing is creating InfoSec as a service. As a person who's sold into a number of the firms, the cost of sale, one of the biggest points of the cost of sale is InfoSec. Even if you have an ISO cert, they run you through a gauntlet. That adds to the cost. This is going to be a pre-clearance exercise so that everybody can just sell right through and get one clearance, one certification, and then they have access to all the customers. This is usually platforms have to create a subsidization to get people to go onto the platform, no matter what it is. And the last thing I just want to say, switching more from the enterprise space, scalable justice and the Modry of everything. Why do I even have to go to court? Richard Susskind's really working on this quite a bit now. Can we have a more scalable system of the version of the justice system? Well, we had an example that's happened right underneath our noses. Modria, which you may not know, is the whitelisted dispute resolution module for PayPal and eBay. And they've solved 400 million disputes online. These are small disputes. E-commerce cannot happen without dispute resolution. Would you continue to buy things if there was no remedy or recourse? No. So people had to figure out how to project law, but into this relatively small transaction. A €100 transaction is not a let's go to court thing. Yeah? But you need some resolution module to solve that, and this is an example of scalable justice. Scaling down to small transactions, not taking the highly costly version of law that is in the enterprise space and it doesn't work down there. Can we have vastly vastly different delivery models. First, yeah, as I said earlier, we'll get chatbots. You know, people say to me, Dan, you know, the one thing you can't replace is the face-to-face interaction between a lawyer and their client. That's probably true. That's probably true. Just an interesting thing. The U.S. military has been experimenting with virtual therapy. One thing I've learned from this, one interesting thing, is sometimes people would rather talk to a machine than a person. Why? What's the judgment of a machine? I'm not saying everybody, but I just would encourage you to don't make declarative statements or assumptions about what people will and won't be willing to do. So I've never met a robot lawyer, but this is the closest thing I've ever seen to one. This is, again, a virtual therapist. So maybe this is the first true robot lawyer of the path there, too. So I'm Dan Katz, Illinois Institute of Technology, Chicago-Kent College of Law, VP at Elevate. This is my lab group, the Law Lab at Illinois Tech. Affiliated faculty, Stanford Codex. This is my blog, Computational Legal Studies. Hit me up on Twitter, @Computational on Twitter, @Computational on Twitter. This is my contact information. Thank you very much for your attention, and we'll open it up from there. Okay.
Yeah. Yeah,
I like that.
Logos, yeah, pretty good.
Yes.
If we have questions, I'd like to ask you to use this so that we can properly hear the questions when we're doing the video editing. We're not going to show your face from close up, so you can ask silly questions if you want. Who's got a question? Has this ever happened to you before? Like, people?
Oh yeah, it happens. My version of that is you completely accept everything I have to say without any. Your silence equals acceptance. That's a version of opting in.
Oh, there we go.
Similar.
There we go.
Okay, there we go. I knew I could get him to talk if I said that. She's not accepting everything I've had to say. That's fair enough.
I'm so sorry.
Okay, that's all right.
No, thank you very much for your intriguing lecture. I was just thinking the title of your lecture, Make Law Better. So I was left with this question, how is legal tech making law better in a, I don't know, like maybe socially benefiting way? What I learned was that it makes legal services better, maybe, makes law more efficient. And when you were talking about some, I don't know, like accidents that were caused by false actions of corporations, so maybe it can even make corporate decisions or human behavior better. But how does it make law better?
Well, I mean, one thing I'd say is the public or most people's touch point with law is through these services. If you said, let's define some evaluation criteria for a successful legal system. One would be, it's not overly costly. It solves some class of problems it's designed to set out to solve. So I try to outline throughout, like, making it more economically affordable. That seems like something. People's complaint, and pretty much everywhere, is it costs too much, and it's totally unclear whether I've even got a good or bad service. And that's even for sophisticated parties, let alone the public. The public's view of lawyers in most jurisdictions is very low, and this is because this is what they experience. So I mean, I sort of take that as we want to not think about. I mean, the typical thing is to think of the content of the law as if that is what people experience. They experience some delivery of that in their lives. And I think some of the criteria I've laid out would make the law less expensive, would make the law more effective at solving the kind of purposes that it purports to have. One of the things I'm a bit remiss about law as an academic field is it was relatively late to empiricism. Like, people would make statements about how the law worked, and then it was just take my word for it, rather than, gee, we could actually kind of evaluate that, whether it works the way you say it works. And that's been a big thing in the last 20 years in the kind of legal academy, and it's awfully late if you look at other fields. Most other fields did this in the 1950s, 1960s. They said, we can't just make these statements about how something works. You have to go out and actually empirically evaluate whether it's true. And so, I mean, anyway, I think this is in the spirit of that form of empiricism. Now, I don't believe all empiricism can capture everything about the world, but I certainly think people's mental sense impression written up as an essay can't do that particularly well either. So, you know, you have to pick from imperfect choices. I think this is less imperfect. That's my not full-throated defense. half-throated defense of the exercise. Other folks?
Hi.
Hello.
I guess I have two questions. They're linked, though.
Okay. 1A and 1B.
Fair enough.
Okay.
So the first one, 1A, would be, what are some signs, as a law firm, that you're on the right track towards innovation? And conversely, what are some red flags that you're not? And then 1B, I think in law firms, often you need sort of a cultural change, a mindset change. And in your view, what are the ways that one can encourage or facilitate that?
Well, I'll start with 1B first. I think you should, well, I guess I don't know if it's 1A or picking pockets to work on rather than try to have the whole firm go at once on a particular, whatever the innovation is generally the success criteria or success strategy, which is find a particular person or group that has any demonstrated appetite for these types of ideas whatsoever. So you tell them these ideas and they say, gee, I'd like to see how we might project that into space, or no, things are good, I don't want to touch any of this, I don't know anything about it, I don't think there's any merit to it. Probably, I would say just swipe past that person and get to the person who leans in and says, well, I don't know exactly how this all fits, but I want to learn more and I want to think about. That's the person you're looking for as a kind of to rally around for this adoption exercise. Because trying to convince the most skeptical person is not a particularly good use of effort and time. So that would be kind of one idea. And then, I think just like anything, I think the firms that have gone down this path is you have to line up a set of projects where you actually show demonstrable success. You measure before and you measure after. By the way, the measure before will be the first time things have ever been measured, so it'll be interesting. But the idea is I think, just like anything, one has to make a business case for an investment, because invariably you're going to be asking them to do something differently or put resources behind something or what have you. And I think everybody has an obligation. I mean, unfortunately, people do not interrogate the status quo with nearly the vigor in this field that they do any change. In other words, let's take all that skepticism and project it to the way you're doing things today rather than any projected or proposed change. But anyway, that's just kind of what you deal with. So my view would be, let's try to put some success criteria down. Let's try to define where we are today and where we might be. And I think, at least in a law firm, you have some obligation to create an economic kind of incentive. Otherwise, you'll say, why would I just not do it the way I'm doing it today? And it's not unfair. I mean, they're not nonprofits, but even in a nonprofit, I think it's true. Where you got to say, we're making it better than it was yesterday, otherwise leave it alone. Yes. Follow-up, 1C.
1C.
Yes.
1B
sub 2.
But sometimes it's actually less valuable from their side, particularly older partners, in my experience, towards making things faster and more efficient, because I've often heard, why should we do this faster if we are going to make more money by doing it the way it's always been done?
Well, then you need to line up the client side of this, the customer side, and the customer who actually is putting any sort of pressure. You're not going to go in, if the customer's never asked the question about, or the client, about what is being done and why it's being done, that is not, on the 1A point, not a good candidate for something to work on. You need a place where there's somebody who's actually holding the person to account. Otherwise, it's not a good place to start, because you're probably likely to burn up trying to do it. So one of the things that's clicked into place is enough customer or clients caring mixed with some kind of invigoration in some of these ideas. A lot of these ideas have been around a long time. They're not like new ideas. Lean and Six Sigma have been around a long time. I mean, Lean is the Toyota process improvement method from the 1960s. Got projected into white-collar work in the 1990s. It's not new. It's new to this space in the last 10 years. Yes, sir. Oh, yeah, we need the box. The box is fun. You've all consented to have that thrown in your direction. It's like...
So very much enjoyed your talk, and I followed your work, so it's great to hear you live. Rather than blogosphere, but one of the things I wonder about this, just thinking about different legal systems, and also the question about making the system better. That, I think this is, what's attractive to me about the discussion like this is it's reducing law to function, right? We're just identifying the functions that law does. But the problem is so much of law is form, right? So, for example, one distinction is between common law versus civil law.
Yes.
And I've had discussions about how legal tech would need to adopt to different common law versus civil law systems, right? I mean, we can elaborate on that, but I'd be curious what you think. But even within a common law system, I think the history of the common law, you go back when we had these writs, and you had to fit everything into a writ. And the way I kind of see this is that legal practice, at least in common law, is all sort of writ-based in the sense that, I'm a tort lawyer, or I'm an IP lawyer, I'm a patent lawyer, I'm an antitrust lawyer. And now we're asking lawyers to rethink their model in terms of function. And so I was wondering, how do you make that transition? Or is it one where there's certain forms, maybe contracts, maybe business organizations, where this function model really kind of lends itself, but others that are more formalistic or rights-based, where there's going to be resistance? Or do you feel that this functional notion will, I tend to like to think about form, but I can see the resistance.
I think it works in places. It doesn't work in like the kind of legal reasoning. I mean, people tend to always want to project this into like these kind of like legal reasoning type of exercises rather than like, let's have a business-to-business transaction happen in a more rational manner. That's a very logical, and so I don't think it's a stunner if you looked at those 2,000 companies. The problems they tend to cluster around are ones that have these, they're approximately these properties that you're describing. So maybe it doesn't generalize to everything. I think kind of the reverse of it is we tend to overemphasize these corner cases that actually don't reflect the massive volume of what most practicing lawyers are actually doing, which is all this other stuff that is actually amenable to what I'm discussing, even if there are certainly examples that it isn't. So like one of the places where the AI and law field, particularly in the continent, has had a lot of trouble is they have this kind of model of law as a logic computer, which is a classic debate in legal theory, which is, are you a realist or are you a formalist? And I think, what does that have to do with all this other stuff? And it's totally valid debate, and I think, it isn't, in my own view, just put it out there, is I'm more of a realist about this, which is, I'm interested in predicting what will happen, regardless of whether it's based on the kind of formalism of the law or something else that's doing the lifting. And that's kind of it follows a classic sort of tradition in legal theory. But then there's all this other activity in law, which is just, it's much more practical, and this is probably where this is the best candidate, actually, than in kind of these more traditional debates, realism versus formalism, or, what have you. I think it can provide insight in the sense that our best efforts to try to give the classic formalistic representation of law do not work as well as predicting as other things mixed with formalism. Kind of formalism plus some realism is kind of empirically tends to work out the best from a prediction standpoint, but which maybe says something about what's going on. I don't know.
One interesting challenge, this thought experiment, is how would you sell this to a civil rights lawyer?
I wouldn't.
Okay, you wouldn't.
I just don't think, I think that's like, there are questions in here which are political or philosophical questions that are not necessarily particularly amenable. The only thing I would say is to say, if you're developing a strategy for about how to change the law, then there are aspects of this that might inform that strategy, yeah? And that's kind of even in RegTech we're seeing. I want to influence a regulator to have a particular position, whether I'm a corporate lawyer or a public interest lawyer or something like this. And certainly a lot of effort goes into this tea leaf exercise of, well, let's try to get in front of this judge to do this thing, or let's try to produce this argument versus that argument, or this version of, that is all being done every day as a kind of as an exercise that could be influenced by some of these kind of prediction-oriented technology, yeah? But it's interesting. But that's still. But I wouldn't say to them, "Gee, we should take a civil rights case and hand it over to a computer." That's a kind of caricature of this. I would never say that. I just want everyone to say that. I do not believe in that. I do think, though, better strategies can be developed about how to do that work using some of these ideas.
Interesting.
Yeah. Other thoughts? A couple here.
I want to ask a question about the fee system, because I think the fact that you're paid by the hour is not really bringing in an incentive, and it's rather stopping all what you've been talking about.
Yeah.
And for instance, if we take productization, if you bundle something and you sell it to different clients, it's not anymore about the time. So what are you thinking is going to be the transition in the fees for lawyers? Because otherwise, all of this is not going to work out.
Well, one of the things these companies do is just sell right to the customer and cut the law firm out, who's historically the go-between. So they go to the corporate lawyer and say, hey, instead of selling this to the firm for whom you might buy the services, why don't you just take your lawyers in the company and we'll give them this technology and facilitate the work that they're going to do. So that kind of they have a completely different incentive structure inside the company, not completely different, but a different one relative to a person who's billing time by the hour. It's definitely a challenge if some of what I'm describing competes with the economic model that somebody has for a person to switch sides. There's no doubt about it. That's again why you've seen more interest in selling through directly to the end customer, particularly in the enterprise space. So sell some of these technologies directly to the corporate legal department rather than through the law firm. They're typically selling to both, but the preferred sale is right to the law firm or right to the corporate legal department, because then it's not refracted through the law firm. Okay. Doesn't always work out, but yeah.
Thank you. Seeing all those developments you have described, the question that keeps bugging me is also how do we make the law better, but how do we make the lawyer better? Meaning, what are the skills, in your opinion, the future lawyer will need in order to succeed in this field?
I assume Dirk has you on retainer for asking that question, but no, I kid. But I mean, I think some of what I described in this paper that you mentioned earlier, MIT School of Law, or some of what we're seeing at a number of law schools around the world, is an effort to try to identify what some of those things are, like teaching students project management and process improvement, teaching them some analytics skills, so they're not kind of numerophobic or something like this. Some basic business and accounting competencies, because especially if you're going to be a kind of business-oriented lawyer, you got to be able to read a balance sheet, for example. I mean, these are basic competencies that are stunningly absent sometimes, and even in folks you'd sort of think would otherwise know these things. So I think we've seen programs. Maybe 24 law schools around the world are trying to move in this direction in one form or another, and it's not like the whole law school, just like it's never the whole law firm, right? So even my school, it's not like everybody is doing this stuff. There's a core group of people that have an interest in this topic, and we have like a certificate program that sort of emphasizes these with a traditional set of legal training blended with some of these some of this coursework. And again, I'm teaching like a blockchain class, and to try to introduce some of those, which is both the law of blockchain, turns out to be a lot of securities regulation, as it were, but around these new topics and principles. So I think there's an emerging but not fully developed consensus about what some of that content ought to look like. Bucerius has an example, as a good example of that through some of the programs, including the summer school, but not limited to the summer school. Other schools around Europe and around the world are producing offerings. Again, to try to accelerate either take existing lawyers and kind of skill them up, or to take would-be lawyers and give them this as part of their legal education.
Do you think that the classic legal education will have some value still then?
Yes. Yeah. Yes. Okay. Yes, I do. I do think that. I mean, if that MIT School of Law paper, there's a lot of familiar courses in there. It's maybe 20% of other stuff. 25%, but 3/4 the same. That's more the same than different. So that's my view. So maybe one more, and we'll break.
It's a throw mic.
It's a throw mic. We have to throw it at least once. Okay, there we go.
Thanks. My question goes into
might as well have a porcelain mic otherwise. I mean, the way they're handling it.
My question goes into the direction of blockchain and legal innovation regarding the profession of the notary, which is one that in the most jurisdictions, I guess, has the function of providing public trust into certain action having happened, maybe something beyond that. And this being able to be replaced by blockchain, at least from what I understand about blockchain, where do you see a future for that profession?
I think that profession has a real challenge associated with it because there's other ways to achieve trust, which is what they traditionally had served. Even I have concerns about let's just eliminate the need for that and purely go to this other system. I'll be interested to see how many of them can transition to an alternative way to deliver the trust exercise. In other words, is there a computational notary process, if you will, if that makes sense, where trust is being delivered in an alternative vehicle, but it looks actually more similar to traditional notary than you might have guessed. It's not fully kind of crypto land, because part of the trust exercise, right? I mean, this is what's not like the kind of, at least the Bitcoin-ish version of crypto land is, we're not trying to have anonymization in most notary. We're actually trying to prove you are who you say you are, which is a different exercise at some level than I want to anonymously procure an item or something like this. It's actually, are you who you say you are? Which we do in the sense that you can produce a hash, but isn't like, and then you're Dan Katz, not somebody else, because that's critical to some other legal function. In some ways, that's an analog version of the problem we're trying to solve computationally. I think the question with all these is, let's try to keep the positive properties and project it in. We don't want a DAO situation where you just think, we don't need any of this law. This is like kind of, I'll just characterize, give a caricature of kind of the crypto folks is, we don't need any law or any intermediaries or any lawyers or anything like this. We can rebuild the entire corporate kind of infrastructure all as code. Yeah? I mean, basically, it's a radical kind of, there's wiping the slate clean of all of this kind of, all the thought that's gone into building kind of the idea of the modern corporation or something like this. I mean, it's clear it was a bridge too far because they had no redundancy, they had no fail-safe mechanisms, they had no ability to reach out to the kind of existing legal infrastructure that exists out there. But I do think that's kind of one extreme. The other extreme is, let's just stick with everything we've ever done and take no stock of all this other stuff that's going on. So the question is, to me, how to build this computational legal infrastructure. We have a lot of analog legal infrastructure. The question, how do you project that? First digital, then computational. So I think that's, especially to the younger folks in the room, that is going to be your charge. I think that's going to be your professional arc as that transition is going to occur. And that creates a lot of opportunities to support the transition because we're a long way from where, as a field, I think we need to be. So hopefully you can be part of, I hope you're part of accelerating that because we need it to solve other functions, in my view. Okay.
Yeah. Okay. I think there are probably other questions around here in the room. You'll be there. Yeah. And I don't want to keep us from drinks. Probably some of us have to refuel here. Dan's going to be around. I hope you guys stick around for a bit, because we have had a dramatic tendency of people leaving very early and leaving us with a lot of snacks and wine, and I don't want that to happen, okay?
That would be a tragedy.
So I think we'll bring it together for Dan Katz, and then we go over for drinks. Thank you.